today this is compliance series, and we hope to always have this event every month. And the essence of this event is to actually inform business owners, to just make them understand the legal implication of certain things and all of that. So, so basically, we are going to be talking about employment contract and compliance. So, as business owners, maybe you are still a sole proprietor, you are a single person, yeah, you just own your business and you don't have employers yet. I know that every business wants to grow, and with growth comes getting more clients and all of that. So you want to grow and you want to scale. So then the next day is for you to employ people. And we have also seen that the courts is filled with plethora of cases between employers and employees. Some can be wrongful dismissal, some can be that and a competitor poached another employee, some people talking about their trade secret, some be fighting over intellectual property. So that is what we are going to be discussing here today. So today we have our distinguished speaker. I know you can see her now, she's smiling. A very, very intelligent lawyer. She's a legal practitioner called properly into the Nigerian bar, and also she's also an HR admin in a company. She's also an associate member of the Institute of Chartered Secretaries and Arbitrators, and she has been doing this HR thing for almost a decade. So she has wealth of experience. Our experience is boom boom. She has wealth of experience. So she'll be telling us what we should look out for. And so I invite Patience. Can you please take the floor, because I'm
joining today's session, and apologies for the delays, right? So let's just get right into it. So today we'll be discussing employment contracts and legal compliance. Well, it's no gainsaying why in recent times you have employers looking for people with legal experience to act as HR managers or practitioners. Reasons being that these things are intertwined. So I'm grateful and I'm honored to be here as a qualified lawyer and someone that has gotten experience by virtue of work experience rather in terms of HR practices. So I would like to tell us a story first, which relates to my first job. That's post NYC after being called to the bar, etc. So I'd gotten a job at, okay, let me say I did an interview at a law firm, and like most senior practitioners do, I hope I'm allowed to say this, they say they want to give you experience, right? So she just told me, okay, I'll give you a chance and you get 50,000 monthly and you can start. So of course I was joyful. I just got my first job. So I started the job and there was no contract signed, right? So no contract signed. We just had a gentle lady agreement now, and I started the job. And after a month, no salary. After 5 weeks, no salary. After 6 weeks, no salary. I asked for salary. It was now becoming like a quarrel. It was like a fight, etc. So finally, I got paid salary. And one day I just thought to myself, this salary that I had struggled to get for after 7 weeks, am I going to now use the same money and still go to the same employer, not knowing whether she will pay me for the second month or the third month? So I quit too. I just stopped going to work. And she was looking for me. She asked the secretary to call me. I just said I wasn't going anymore. Reasons being that it was as though there was no agreement between us because you delayed my salaries, no explanation. I'd asked for my salaries. You made it seem as though you were doing me a favor. So that is why employment contracts are very, very important. So the things we'll be looking at today are the key elements to be included in employment contracts. Why is it important to have a well-drafted employment contract? how you can ensure legal compliance even in your recruitment process, because recruitment is the like bedrock of every employer-employee relationship. So there are also things you must put in mind while recruiting or putting adverts out there for recruitment as well. Importance of legal compliance in employment process. I will look at some decided cases and we'll conclude. So I'll run through this as quickly as possible. So what are employment contracts? Like every contract, it's an agreement between two or more parties. So A is saying, this is what I'm offering you, this is what you do for me, and in return, I'll compensate you by doing this, etc. So a contract of employment is an agreement between an employer and employee, and it sets out their rights, responsibilities, and duties. So it's not a one-way thing. In an employment contract that is properly drafted, you see the responsibility of the employer as well as responsibilities of the employee. Fine, the employee has to perform some duties. You have to ensure that you perform your duties as stated in the job description. Can everyone, as employees, you are to ensure that you perform your duties as written in the job description, and in return, your employer pays you salaries or some other compensation benefits. So it's a two-way thing. Each party has responsibilities, duties, and rights to enforce in the contract. So another question that you might ask is, must employment contracts be in writing? Just like I made earlier reference to my first job experience. So you might want to ask, must we have a written contract? The labor law or the regulations guiding employment contracts in Nigeria doesn't specifically say that at the inception you need to have a written, provides is that by virtue of section 7 is that within 3 months you should issue a written contract to the employee within 3 months, and this is important. So you can start off on an oral agreement, but if someone has worked for 3 months, you have to ensure that that person is given a written contract clearly stating out the terms of the employment, etc. Okay, so now the next question is, what are the key elements to be included in the employment contract? So I'd like to look at it from the part of the employee as well as the employer. So as an employee, there are things you should look for in your contract before signing. As an employer as well, there are things you must include to protect yourself, right? So Josephine in our introduction had talked about trade secrets, how you can protect that the organization or the employer can protect itself against divulging trade secrets even after the employee has left the organization. So these are the things that must be included in your contract. So the first thing is job title and description. Of course, the employee needs to know what his responsibilities are. Reasons being that he or her performance will be judged based on those responsibilities. So it's very important to lay it out there. These are the XYZ things you are going to do while in the employment of this company. If for any reason there's a change in job description, of course, that would now, there'll be a new issue. Let's say, for instance, there's promotion. Um, Let me use myself as an example. I started off as a graduate trainee, then I was promoted to HR officer, then subsequently manager. So for each of these promotions, ideally a new job description will be issued, and you need to sign that as well, accepting that these are your responsibilities, knowing that performance will be judged based on those responsibilities. So that is very important. Also, the term of the contract. So it's not applicable in all settings, but there are some persons that are hired on contract basis. If someone is hired on a yearly contract basis, it's important to state the terms, knowing that, okay, at the end of this term, both parties can come to the table and talk on whether they need to renew or whether they need to end it at the expiration of the term of the contract. So it's very important as well. Salary and benefits, this goes without saying. There are a lot of statutory requirements, especially as it relates to pension, as it relates to taxes, as it relates to insurances that employers must have. Employers must have group life insurance, etc. So all these things are encompassed or are stated in the salary and benefits or the compensation package. So from the compensation package, you would know if you are entitled to a health insurance, which there are statutory requirements as well, saying that you must have health insurance for your employees rather, if they are up to a certain number of persons. So all these things you must put in mind, knowing that failure to abide by these statutory requirements can result in fines or penalties, or you can even lose your business licenses. So they are very important and things you must include in your contract as well. Termination and notice period. Of course, this is very important. The labor law does prescribe some the length of notice for some employment. I think for 1 year it's about 2 weeks, right? But if the terms of your contract says you must give 1 month notice after working for 6 months, as is common with most of our employment contracts, then you have to abide by that. So termination and notice period determines, or it tells how parties intend to determine the contract. So if an employer says, I no longer want you as my employee, then that termination clause would spell out the process by which that person can say, or that lawyer can terminate that agreement. So usually you see a period of notice or payment. So if an employer can't give the required notice, then he can proceed, or he or she can proceed to give payment in lieu of notice. And this goes both ways. As an employee, if you can't give the required notice period, then you have to pay salary in lieu of notice. So it's very important to clearly state that, so that when disputes arise, it's easy to make reference to the terms of the contract. Another thing is confidentiality and non-disclosure. Like I said, these terms do not only protect the employee, they also protect the employers as well. So confidentiality is something very key. As a business owner, you have trade secrets, and by virtue of your employees working in your organization, they are exposed to these trade secrets, right? As a HR personnel, they are exposed to information about the business, they're exposed to revenues generated, they're exposed to many things, right? So it's very important that this confidentiality clause and non-disclosure clause is included. So I'll similarly link this also with the non-compete clause. So non-compete clause usually it survives the employment contract. The labor law allows for up to 2 years after the person must have left the organization, all in the bid to protect the organization's trade secrets as well. Leave entitlements, yes, very important. You need to have a day of rest. Um, the labor law prescribes that at least 6 days in a year you have to rest, right? So aside that, the terms of your contract might increase those days. So the minimum requirement is 6 days, but the terms of your contract can go up to as 22 days, a month, etc. All right. So let's quickly run. I hope I'm not talking too fast, because I just really need to run through all these things. Okay. So importance. So why is it important to have a well drafted employment contract?
No,
So
you
like I
are
said,
not. But we can,
okay, thank
our viewers can type in the comment section.
okay. All right, thank you. So why is it important to have a well drafted employment contract? So like I said earlier, I'm looking at this from the angle of the employees as well as the employers. So first, for the employees, it helps to clarify duties and responsibilities. Like I said earlier, your performance is judged on your ability to perform your duties and responsibilities. So if these are clearly stated out from the beginning, so it becomes obvious to you as an employee what the expectations are, and you can now channel your energy to ensure that you perform as the contract requires. So it provides clarity. I, as an HR person, will not be expected to be doing something of a chemist. Reasons being that that's not my job description. I don't have the qualification or requisite knowledge to be able to perform optimally in such role, except I am being trained first before giving such responsibility. So it's clear what my responsibilities are, and the grounds or the terms on which my performance will be based or judged rather. Another thing is that it ensures job security for employees. So you know, as an employee, that your employer cannot just come and say, I don't like your face today, come and go. Fine, even if he does come and go, you know that there are legal implications for that. You know that he ought to give you notice so that he's not in danger of wrongful termination. And if he's not giving you proper notice, you know he has to pay you in lieu. So when all these things are not done, it can give rise to an action in courts, right, against the employer. So it helps with job security. You are able to plan yourself. If there's a notice in lieu, or sorry, if notice is given, you know you have 1 month to look for another job, right? So it helps you plan yourself and gives you job security. Maintain trade secrets and confidentiality of the employer. I think we've overflogged this issue already. So it's one of the major importance of having a well drafted employment contract. Dispute resolution. So when all parties know their responsibilities, it gives little room for dispute to occur, right? So you don't argue, oh, you're supposed to do this, you're supposed to do that. Why didn't you do this? Why didn't you pay me my salary? It's clear that at the end of every month, you should pay me my salary. So it helps in dispute resolution. Also, when for any reason there's a civil litigation or civil suit against maybe the employer, with a properly drafted contract, it's easy to present evidence before the court on what the terms of your contracts were, and you can now enforce those contracts. So that's why it's very, very important to have a properly. So when you get an offer letter, let's not be in the frenzy of trying to, oh, I finally gotten a job. It's very important to ask what the terms, or to see what the terms of your contract are, to see if they are for your benefit or not. You can ask questions. Fine, you get an offer, you don't like the amount of leave days you are given, you can ask for a review. That, oh, I think it would be fair to have 18 days instead of 10 days. So it gives you a bargaining chip when so it's I'm just trying to advise that as much as we are excited about getting a job offer, it's important we review the contract. Important we see that these companies or the company employing you are compliant with statutory requirements. Generally, relates to pension, taxes, remittance, etc. Is very key. Also, it helps you attract and retain the best talents, right? So you have a properly drafted contract. Of course, if the compensation package is very good, very competitive, it helps you attract and also retain the best talent. People wouldn't want to leave the organization because you are paying well, you are rewarding their performance well. So that's why it's very important to have a properly drafted employment contract. So now I'll be moving quickly to how we can ensure legal compliance in the hiring process. So hiring process is the first stage of recruitment. Like I said earlier, you put out an advert, you invite people for interviews, etc. There are some legal compliance, even though they are not clearly spelled out, but you must adhere to as best practices. First one is freedom from discrimination. So say for instance, you put out a job advert and you say we are looking for a fair lady that can act as receptionist. That sounds discriminatory in nature, being that you are discriminating against people that are of dark complexion. So you have to be careful, even from your adverts. Ensure that you are not putting sentences or things that can be described as discriminatory. Section 42 of the Nigerian Constitution protects people against discrimination on the basis of sex, religion, etc. So we are protected, or every Nigerian is protected from discrimination. So as an employer, you ensure that the messages you put out there are not discriminatory in nature, even at the point of adverts. So don't discriminate on basis of age, religion. Don't say we are looking for a Christian, this. and you put it out in a public space, that's a discriminatory language. So we must be mindful of that. Also, we need to be mindful of legally protected persons. So, like the disabled people, persons living with HIV or AIDS, minors, these people are protected legally. So, we must be careful. If, for instance, you have someone that is disabled come to apply for a job, um, you must have evidence that the only reason why you are rejecting such person is because the person maybe is not qualified for that role, or the person would be unable to perform the functions or duties of that job by virtue of his disability. You don't just discriminate because the person is disabled. No, 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 I can't hire somebody that doesn't have one hand or has only one functional hand. No, those persons are legally protected by the law. So we must be very careful as regards that. Another thing to bear in mind is data privacy and protection. So we have an act, I think was passed in 2023. That's the Nigerian Data Protection Act 2023. So it protects the data. And why I'm bringing this out is that during your hiring process, you are exposed to a lot of information. So, for instance, you have put out an advert and I apply. I send you my CV. In my CV, you have an idea of my name, maybe where I'm from, depending on the role I'm applying for. Some job descriptions would, maybe job roles like graduate trainee entry level, might ask for your age. And to prove that you are at that age that they require, you send your birth certificate or you send, so that's a whole lot of information you get in your hiring process. The law sees you as a data controller. And as a data controller, it's your obligation to protect all the information and data that is coming to you. So you have to protect the interest. So you know that such information should not be leaked to hackers on your account, because that person has entrusted you with data, and that data needs to be protected. So that's another thing to bear in mind. So when you are getting all those CVs, ensure that you are getting them in a secure means, or you have a controlled means to ensure that those informations are not just passed out or get out of your control. Okay. Another thing is pre-employment assessment. So let's say you've gotten the right candidate and now you are doing background screening and background check. It's okay to write to the person's previous employer, right? But if you have to do like a security or criminal background check, it's ideal, it's best practice to ensure you get consent of that person you are seeking to hire before proceeding on such. Because, of course, like the law provides, everyone has a right to privacy. So if you want to run a background check on someone, ensure that you have that person's consent. Usually, in practice, the let's say you want to do a background check of a former employee rather, the security or the background check agency would write to the person that is being about to be checked, and the person will give like an authorization. Okay, I authorize you to get this information from my previous employer. That authorization will be forwarded alongside the request to get information from your previous employer. So consent is key. So you cannot just say because you want to check, you just do it without consent. You must be mindful that consent is key. So before you check, do background checks and ensure you get consent for the release of such information. All right. Okay, so why are we having this conversation? So we said a lot of things about legal compliance as relates to employment contracts, etc. So why are we having this conversation? The first thing is that it helps to mitigate financial risk. No employer wants to be in court because they are sued by their former employee. So you must be mindful from the stages of hiring, even the during the course of the employee's employment in the company. You must be very, very mindful. Mindful that you don't engage in things that are discriminatory, you don't victimize the employee, because you don't want a suit in future. So when we move to the case studies, we'll see one of the cases that the former employee got a considerable amount of money in damages by reasons of of discrimination, victimization, etc. So it's very, very important. Also, it protects the employee from forced labor. In Nigeria, we already have a fixed minimum wage, which is 30,000 as at today. So you know that no matter who you're employing, whether it's a cleaner, whether it's a gateman, you know that you have to pay them that minimum wage. So that way it protects them from forced labor. You don't want, just imagine the current situation of Nigeria, right? And you are employing somebody and paying the person 10,000. Do you want the person to steal? How is the person going to get money to go to work? How is the person going to transport himself or herself? So putting requirements like minimum wage helps to protect the employees from forced labor, ensure that you are being compensated for the performance of your job, right? Okay, also ensures in equal opportunities. So I'd made reference to adhering to non-discriminatory practices even in the process of recruitment. So that allows for equal opportunities. So I know as a dark person, I can apply for the same job a fair person will apply for if we are both competent for that role. Okay, so I'm not being discriminated against because I'm Christian or because I'm a Muslim. So it ensures for equal opportunities. If we are competent for the job, all of us can compete fairly and the best man wins or the best woman wins. Okay, so that's why it's important to have legal compliance in the employment process. Another thing is business opportunities. Now, this is from the angle of the employer, which is very key. I'll make reference to an audit we did. So we had done a human rights audit in my organization, I think in 2022. Okay, so we did that audit on the instance of one of our clients. So our client had requested that an audit firm comes to audit us on the grounds of human rights compliance. So we provided evidence that, oh, we pay our staff well, we ensure we pay above the minimum wage, we ensure that our staff go on leave, we showed them employment contract, samples of employment contract, and at the end of the audit process, we got a very, very high percent, I think 96%, as regards compliance to human rights. So it shows you that some companies that are standard would want to see evidence of your legal compliance before they even give you business opportunity. If you're familiar with the oil and gas industries, as part of tender requirements, you have to show compliance to your PENCOM, show that you've been paying your pension of your staff, NSITF, tax clearance, insurance, basically. So all these things would give you business opportunities. So if you are a company that doesn't comply with these statutory requirements, you won't get opportunities to do businesses with those standard organizations. So very important. Business opportunities come. Legal compliance helps you to get good business opportunities. Another thing is quality management system. There's something we call ISO certification. So if you have ISO certification, it shows that you have good QMS in place, good quality management system in place. And with an ISO certification, you get like, it's almost like an esteem. You are able to do businesses, you are able to get loan facilities because you are ISO certified. So it shows that your business is run in an effective manner. So that's what legal compliance also will get you. Another thing is attract investors. So there's something we call credit rating, right? So there are credit rating firms that comes audit your processes and procedures and now give you a rating. And with that rating, you are able to approach banks, financial institutions to get loan facilities. So legal compliance as well would help you get this, because when they are doing that audit, they'll be checking how compliant are you as regards pension remittance, how compliant are you as regards tax, payment of taxes, etc. So when you are legally compliant with all these employment requirements, it helps you attract the right investors. You can get investors investors for your business by being legally compliant. All right, so quickly let's move to, I mentioned earlier that there are case studies. So I have two case studies we'll be looking at. The first is a case between Mrs. Scholastica and Samuel's Lodge. So this was a case of an employee that was forcefully terminated. So they no longer required her service and came in, barged into the place she resided and forced her out of the lodge because she was working at a lodge. So they forced her out. Then in the process, her phone got damaged, etc. The employer had failed to pay her 2 months' salary and terminated without notice or payment in lieu of notice. So that's a summary of the entire case, but you can read it up as well. So when it got to the court, that's the National Industrial Court, the court held in her favor and asked that the employer, or the defendant rather, pay that outstanding sum of 2 months unpaid salaries, pay in lieu of notice, and also replace the phone that was damaged in the process of ejecting her out of the lodge. So it's very, very important. That shows you that the court also will stand um, on the side of justice if an employee or previous employee is being treated unfairly. So you cannot be owing your workers' salaries, right? Because it's their right, it's their entitlement. So ensure you pay your salaries on time, ensure you terminate properly. Because most times the cases you see in National Industrial Court are usually as a result of wrongful termination. So if the contracts clearly state out the terms for termination, abide by it. If you can't give the notice, pay in lieu, and everyone goes their way peacefully. Another case study I have here is Mr. Ifechukwu De Adigwe versus FBN Mortgages Limited. So in this particular case, the employee had resigned. Then after resignation, the employer started making some claims that during the employee's period of employment, that some transactions happened that were this, that. So the employee finally got a new employment. And of course, like most employers will do, they will ask for work reference from your previous organization. So they asked for work reference, and the former employer wrote some very, very nasty, injurious work reference for that ex-employee. So they took the matter to court, and the ex-employee took the matter to court. And the court held in favor of the employee and awarded 3.8 million or 3,840,000 naira as damages for injurious work reference. So that reference was given with malice. So as an employer as well, when an employee leaves your employment, don't start giving malicious comments, statements about the previous. Just state what happened. Not that because you are angry that the employee has left your organization, you now give very injurious and harmful work reference that are defamatory in nature, saying things that are untrue, are unfounded or false, just because you are not happy that the employee has left your organization. So with that, let me come to the conclusion. So in summary of all what we've said, it's very important as an employer and also as an employee to ensure that you review your contracts. It's very important. You see what you are entitled to, you see what your duties are, because it guides your employment. It guides all what you do during the course of your employment. It's very, very important. It protects you, it protects your rights. As an employer as well, it also protects your trade secrets. So all these ensure that businesses can thrive in a positive work environment as well. So in a toxic work environment, you typically see that at the instance or at the inception of that employment engagement, there was no clear definition of rights and obligations of both parties. So it breeds toxicity. But when it's clear, employer knows I must pay salaries so that I don't lose my license or lose my right to business. Employee knows that, oh, I must perform my duties so that I can have a claim for my compensation. So that's just the summary. And thank you for your time. I hope everyone heard me. And um, that will be all from me. So, do we have any questions so far? So, do we have any questions so far?
Okay, thank you very much, Patience. Wow, 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 wow. In fact, we're supposed to be this live session is not supposed to be free. So I learned so much, really, I did, especially when it comes to the compliance part. You opened our eyes to how important employment contract is and the compliance steps that you need to take into consideration, and the fact that it can actually affect you when it comes to business opportunity as an employer, and when it comes to attracting investors, getting loan for payment is so amazing, really. In fact, there's more to it than that just meets the eye. So I'm so excited, and I thank you very much for for sharing and for sharing from your wealth of knowledge. Please, if you have questions, we can ask questions. So there's this issue that has to do with mental the workers' mental health.
Okay.
Sometimes you work in places where your employee just talks down on you, he talks down on you, tell you that, oh, you're not doing well, you're not doing your job well, and it affects the mental health of the employee. So what steps can we take? How do you advise an employer when it comes to the mental health of their workers, and how do you advise the employee to, and can we couch this into our employment contract?
Okay. Thank you very much. So, like we said, employment contracts are just agreed terms by both parties, and it can be reviewed. Although many organizations tend to have a format for you can ask for this. For mental health, I would say ensuring that languages used in the office are official. We don't use derogatory languages in the office. I know organizations usually put in place disciplinary measures. So that's one way internally to try to curb that. So, for instance, you have a boss that's always talking down on you. There's a process to report such boss. Lay a complaint to the judiciary, and disciplinary committee will be set up to investigate the fact of the case to see if there's really a case of derogatory use of words in the workplace. So internally, that's how a employer can curb against that. As for the law protecting you, I think one of the cases I mentioned was giving malicious statements about a previous employer. So I believe an employee rather, can also make a case, present the case that, oh, I'm being discriminated against in my workplace, I'm being victimized. But such employees should show that it took the internal process first. So if there's an internal process for um, reporting such cases, such employees should explore that option first before now bringing a civil suit for victimization in the workplace. But I believe, yes, an employee can actually sue the organization if he or she is being victimized in the workplace. Yes, I believe that is possible. Does that answer your question?
Okay, thank you, Patience. I guess there are no questions now.
Does that answer your question?
Yes, yes, it
Answer a
does. It does.
question.
It does. It does. Thank you so. Thank you so much. Thank you for joining us. Thank you for the patience. Your name is Patience. Thank you for the patience and thank you for the time. Thank you, thank you, thank you. So I think we'll be ending the session now. We'll finish it now. Thank you. I will
I,
hope to
I
get
can
more of it
see a
because
question.
I know that we'll be discussing some other issues as regards to employment and HR, maybe sometimes in the future. A question.
Yes, in the
Okay.
comments. In the comments.
Okay, so okay, what's the question? Can you read it out?
Okay, so
Okay.
what do
Okay,
you
maybe you should
advise
address
someone
it.
who started? Okay, the question here is, what do you advise someone who had started a work without getting an employment letter? She then got to know that the breakdown isn't the same as what was discussed, though the fellow has not signed yet. Well, I think while I started, I gave a personal experience of myself starting my first job without signing an employment letter. And so I understand the position she is. The thing is, contracts are agreements between two parties. If she's not okay with the terms of what is being presented to her as a formal letter, then she might have to leave the organization or look for job elsewhere. Started work without getting an employment letter. She then got to know the breakdown isn't the same as what was earlier discussed. Does she have another question would be, does she have proof of what was earlier discussed? So from what I'm getting, it was discussed orally, and oral contracts are impossible, but the measure of proof is what would now be an issue. So you'd have to prove, you need maybe someone else to um, correspond, collaborate with what you are saying as proof that this is what was agreed at the inception. So it's a dicey situation. I wouldn't advise the person to sue, because like I said, it's now be a question of what that person can prove. And with law, if you don't come, the courts, yes, they might know that, okay, there's a tendency that there's elements of truth in this, but you have to present facts before the court. You have to present proof before the court. And if you don't have that, it becomes difficult for you to win your case. So I would advise that the person talks, converse, see if there's option to renegotiate, insist on what was discussed at the beginning, and hopefully she's able to convince the employer. And also she must ensure that she gets the written document, because that is the foundation for this issue in the first place. So now she'll be renegotiating to ensure that there's a written document to confirm what the terms are. So I hope that answers your question, Mr. Adeshina. Adeshina, sorry.
I think Mr. Additional can type yes in the comment section so that we go. Okay, okay, he said
All
yes.
right. Thank you so much. Thank you so much.
Okay, so in the absence of no question, so in the absence of no question, we should be ending the live session now. Let me see, check. There's no. Okay. All right. Thank you. Thank you, everyone, for joining. Thank you. See you next edition on compliance series, and we hope that the next one will avoid the glitches that we experienced in the beginning. Thank you so much. Thank you for your patience. Thank you. All right. Thank you, patience.
All
Bye.
right. Thank you. Bye.